All right, in the lecture today, we're going to talk about two basic things. Broadly speaking, we're going to talk about identity issues in negotiating, and then we'll talk about legal ethics, and I'll pepper it with some other sort of broader, just sort of ethical matters. Let's talk about identity issues first, and what does this mean? Well, we're talking about, do things by which people identify themselves matter in negotiations? That could mean things like a person's sex. Are they male or female? Does that matter? Is someone, does their race matter? Does race factor in, or doesn't it? Does someone's cultural background matter? Does the place where the person is actually living matter? I mean, in other words, if you are Japanese, does that, and you live in Japan and you're negotiating with someone from the United States, does that matter? And obviously vice versa for those of us who live in the United States. If we're negotiating with someone from Japan, does it matter? Just as an example. So we'll talk about that, and then we'll talk about legal ethics. And this is a legal negotiations course, and so we're talking about legal matters. And so we do need to talk a little bit about how do the rules apply, do they apply, and what rules apply to lawyers as they negotiate. You've already come into contact with Rule 8.4, which I threw out at you recently, and we'll talk about some others tonight very briefly. Now, I'm going to be glancing in, that direction. And so once in a while you'll see me look over. I've got some notes that I'm working from this time, so forgive me for that. First, let's talk about identity issues. Two basic views of time: polychronic and monochronic. Now, what does this mean? Poly obviously means many, and mono means one. Let's start with monochronic. Westerners generally, and particularly people in the United States, tend to be monochronic. That is, we see time very, very important and very, very meaningful. And so we get very caught up in time and things starting on time and finishing on time. If we say we're going to start at 1 o'clock, we start at 1 o'clock. In fact, to give an example that was in the sports world not too long ago, although maybe some of you won't remember, but for me it was a big deal. I'm a New York Giants football fan, and the then coach Tom Coughlin, famously said, if you're 5 minutes early for the meeting, you're late. So it gives you an idea of just how seriously Westerners often, particularly those of us in the United States, often take time. We want things to start and end precisely when we say they will. And we get frustrated and weirded out, and thus we have all kinds of road rage and other sorts of things that happen because people are just freaked out about time. Let's view that against other cultures. Middle Eastern cultures, often Mediterranean cultures, often view time as a little different. Things kind of tend to be a little more flexible. I'll give you a good example. I know this from both a professor at the seminary where I attend, as well as a good friend. In fact, the house you see me sitting in right now, this is my little office in my house, I purchased from this friend who is a missionary in Brazil. And in Brazil, when they say they're going to start church at 11 o'clock, that means anywhere from 11 to 12:30. I mean, people just sort of wander in, and eventually, when there are enough people there to begin the church service, and it appears that for the most part, everybody who's going to show up has shown up, they start church. Well, for us in Western culture, we start precisely at, name your time you go to church, 11 o'clock. 10:45, 1 o'clock, whatever. We start precisely. Somebody's singing, somebody's praying, somebody's doing announcements, somebody's reading a scripture verse right at 11 o'clock, right? And so you can see that difference. That's a real difference. And look, it factors in when you're negotiating, because if you're negotiating with someone from Brazil, you need to know that. And you cannot dismiss it. It doesn't mean you turn it into the be-all and end-all of your negotiation, but it does mean that if you say let's start at 11 and they say fine, and suddenly it's slipping into 11:15, 11:20, 11:30, and they're not ready, or they're not there, or they're not on the video screen because you're maybe doing it through Skype or some sort of means like that, and you're starting to get frustrated. Don't. Understand that there's a cultural difference here, and just, give them a break, I guess. And just kind of realize that that's a cultural difference, and it's real. That doesn't mean that it'll happen every time. It doesn't mean that every negotiation with a Brazilian will be that way. It doesn't mean that every negotiation with a Middle Easterner will be that way. They may very well be very prompt. Who knows? And they may find your promptness irritating. I mean, it goes both ways, right? And if you're tapping your finger, or you're, blah, 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 and you're, what? Come on, I got things to do. Well, I'm not wearing a watch, but you know what I mean when I'm pointing at my wrist, right? I got things to do. It's not a steadfast rule, obviously, but it's something to consider. What about some other things? Space orientation, cultural. Again, this is an identity issue with space orientation and cultural matters. The fact is that Westerners, again, tend to be oriented towards space. In other words, I have my personal space, right? And you don't violate my personal space. And so that means that if we are negotiating, I sit on one side of the table and you sit on the other side of the table, if we're face to face, okay, or if we're together. There's not a lot of touching among Westerners, generally speaking. Now, I will tell you, I'm a touchy type of person. I like to, when I talk to people, I like to touch them. Now, maybe that's just the sort of pastoral person in me coming out. But I particularly older people, and I deal with older people a lot, just by happenstance. And so maybe that's why I like to do that. I like to put, because I don't think they probably get as much of that tenderness oftentimes. Westerners, we just don't, generally speaking, we're not real touchy-feely for the most part. Other cultures, much more touch, and so again, or they get closer, or they want to sit on the same side of the table and look right at you. That's another issue, looking in the eye, for instance. So we got to be careful about these space orientation. Central America, a slight movement of the eyes may indicate embarrassment, showing respect or disagreement, for instance. And so you have to be careful about that. You don't want to roll your eyes when somebody says something that you think is ridiculous. Asian settings, looking down is usually interpreted as a sign of respect. Now again, does this mean every person from Japan, if you look down, that you're being respectful? Probably not. Probably not. But does that mean that oftentimes that they will interpret it that way? Sure, it does. Again, you've got to sort of just be cautious and careful when these things might occur and when they might come into play. It doesn't mean that you have to have hard, fast rules. It just means that you need to think about it. Just, get it into your mind. Here's some things that I found from Michelle LeBaron, who is at the faculty of the University of British Columbia and who had been at the faculty at George Mason University in Fairfax, Virginia for a number of years. And she is apparently well known for her research and work and thinking about dispute resolution. And here's some things that she came up with over time. This isn't me talking, this is her. And these are differences between American negotiators, Japanese negotiators, Chinese negotiators, and Brazilian negotiators, okay? Top number one priority of American negotiators, preparation and planning skill. I want to prepare well, and I want to be organized, and I want to have everything prepared right down to the last possible thing. Well, that sounds very American, doesn't it? Japanese negotiators, dedication to job was their biggest matter for them. They're dedicated to getting the job done. Okay. Chinese, and this is Taiwanese negotiators, not mainland China, but Taiwanese negotiators. Persistence and determination was their number one sort of goal, if you will. And then Brazilian negotiators, interestingly enough, preparation and planning skill. So same as the Americans. So there's some similarity there. Out of the good things that these four groups of negotiators saw as important, integrity was the last of the, sad to say, the last of the group of good things. that American negotiators thought was important. Verbal expressiveness was the last thing on the Japanese radar. Intelligence was the last thing, judgment and intelligence was the last thing on the Taiwanese perception of success, and then competitiveness was the last thing on the Brazilian sort of radar for determining success in a negotiation. And so, again, how do these things matter? It can be very, very complicated, of course, when you're dealing with different cultures. My point isn't to say you got to spend a gazillion hours preparing and skillfully getting ready for the negotiation if you're negotiating with someone from another country. The point is you have to be sensitive to the possibility that you might say something or step on someone's toes or do something that you don't even recognize you're doing that could end up causing an issue. So you just need to be sensitive, and it might be worthwhile anytime you're going to negotiate with someone from a culture that you know is very likely different than yours, to think about it a little bit and do your homework. Do a little homework. And you can't get away from it, right? I'm an American, so preparation, right? Do your homework. But again, you may save a company, you may save your law firm, you may save your if it's a government agency, you may save millions of dollars, you may save a lot of heartache. Who knows? So you could be the reason that there's not a war, right? You never know. This is what a Japanese negotiator wrote about Americans. Okay, so just something to chew on. And this is what he said. American negotiators tend to be competitive in their approach to negotiations, including coming to the table with a fallback position, but beginning with an unrealistic offer. Absolutely. Okay, I've seen that, let me exaggerate, a bazillion times. Okay, I don't know if a bazillion is more than a gazillion, or even a zillion. I don't, whatever those numbers mean. I've just seen it again and again. It happens all the time. It says that they are energetic, confident, and persistent, and they enjoy arguing their positions. Well, again, true. I mean, that's me to a T, right? They see things universally. They like to talk about broad applications of ideas. They concentrate on one problem at a time. That goes with that monochronic sort of thinking. They focus on areas of disagreement, not areas of commonality or agreement. Well, that's true oftentimes with Americans. We tend to focus on the areas where we disagree, but why do we do that? Because we feel like, well, what's the point of talking about what we agree about? We already agree about that, right? Who cares? But this is just a Japanese guy who's writing to a Japanese audience saying, these are the things you need to be thinking about, right? He said, Americans like closure and certainty rather than open-endedness or fuzziness. Yeah, true. All right, so on the American front, let's talk about a couple things. Gender differences. I personally have not noticed any significant difference between male and female negotiators, except this. And this is just among students. And take this for what it's worth, okay? Just observation. Typically, I would have people, when they're doing face-to-face negotiating, when I was teaching on campus in the classroom, I would have people in teams, and two per team. And this was an interesting phenomenon that would occur when I would end up with two women on a team. And I usually pick the teams at random, but oftentimes I'd have enough ladies in the class that I ended up with two ladies on a team. And I had one class where I had a large number of young ladies in the class and only a few guys. Now, I usually had anywhere from maybe 16 to 20 students, sometimes 22 or whatever, something like that. Anyhow, this one class, for whatever reason, I probably, out of the 20 students, let's say I had like 13 women or something like that. Anyhow, so I had groups of ladies where it would be two women negotiating against two women. And I will tell you, and again, this is anecdotal, so you take it with that in mind, those negotiations did tend to be, interestingly, a little more acerbic, shall we say, a little more spirited, okay, than even negotiations with guys who I knew were just super aggressive. And so it was very interesting to watch that dynamic in play. Now, again, that's anecdotal. I didn't study hundreds. In the book, there's an article by Charles Craver. I don't know if I assigned it or not. I don't remember. If I didn't, you might want to take a look at it briefly. He talks about race issues, but the gender issue is pretty much the same thing, and said, look, I've seen hundreds of these. I haven't seen any real difference. And to get to that, I have not observed any difference between whatever race people are. Again, I'm talking about American students 99.9% of the time. I've not observed any difference. I think that's the kind of thing, particularly when you are negotiating within a general culture that is the United States, it's probably something that means almost nothing. It means whatever you make it mean. So if you don't let it mean anything, then it doesn't. So I would not get too wound up about it. A couple other things. Well, last thing about identity issues, rural versus urban. I spent a number of years of my life living in rural settings, and I've also lived in the city quite a bit. And I went to high school in a very, very rural place. And I can assure you that the way people think, and some of you are probably from rural areas and you know what I'm talking about, people in rural areas simply aren't as, generally speaking, this is just a general observation, they just aren't as aggressive. There tends to be more small talk, there tends to be a little more, and I hesitate to say this, but I think it's generally true. They tend to be a little more polite. They're not in as big a hurry as people in the city. And so there is a bit of a difference. Again, it's not huge. It probably doesn't matter that much. But I would say this: if you are a city person and you are going to a rural setting to negotiate, just be on alert that you're probably going to need to chit-chat a bit more than you might if you were negotiating with someone in an urban setting. Maybe, maybe not, but probably. Okay. And again, that's just a general observation. It's not hard and fast. It's not a hard and fast rule. All right. So let's move to legal ethics. Okay. And so we're moving from identity issues to ethical issues. 3 rules that you need to know about, and you can find them. I don't know if they're in the book. Frankly, I know they're mentioned in the book throughout, but I don't know if they're ever put in the book anywhere. I don't remember off the top of my head, and forgive me, I didn't look. But we have three rules from the ABA model rules, and you can find those online anywhere. Just put in ABA model rules, Google it, Yahoo, whatever search engine you use, and it will come up, and you can look at these. First one is Rule 1.2. Rule 1.2 governs who controls what as between the lawyer and the client. Lawyers are permitted to control the means, and clients always, every time, control the ends of the negotiation, with one large exception, and that is the client is not permitted to ever get the attorney to do something illegal or unethical. So in other words, the client can't say, I want you to negotiate this matter this way, and then proceeds to tell the client to do, the lawyer, to do things that are unethical or illegal. Obviously, the attorney cannot do that. And it doesn't matter what the client wants. At that point, the attorney has just got to say, listen, either we negotiate this ethically and legally, and frankly, I would argue, and I know from my standpoint, I always would tell clients that if I thought something they were suggesting was not moral, that I wasn't going to do that either. I wasn't going to engage in immoral behavior. And we'll talk about that in just a minute, because that's a little bit of a different issue than the legal niceties. So Rule 1.2 gives the attorney control of the means of negotiation. That is how the negotiation is going to take place. The lawyer is not bound by the client's requirements to negotiate in a certain fashion, although, again, that's between the attorney and the client, how they want to decide how that's going to work. The lawyer certainly is free to, within the parameters the client has given the lawyer is free to negotiate however the lawyer sees will best serve the client's interests. Clients always get the last say, and so clients always control the final decision. The attorney has to get authority from the client before ever saying, the magic words, we're done. Yes, we've got a deal, whatever the words might be. Rule 1.4 requires that the attorney keep the client informed at all times. And this is a general rule that just says attorneys have to keep their clients informed of legal matters in which the client has an interest. But in negotiations, obviously, that's something that goes on regularly. And I can assure you that that was a very fundamental part of any negotiation that I've been involved in ever. The client is always routinely and regularly informed that here's what's happening in the negotiation. What do you want to do? And so, I mean, that's a simple call. Got to tell the client what's up. That's just simple and easy. Okay. Rule 4.1 gets a little trickier because Rule 4.1 says that lawyers have a duty to tell the truth. What about bluffing? Isn't that lying? What about the idea of puffing versus bluffing? Bluffing is you act like you have something that you know you don't have, or you act like you don't have something that you do have, right? Most of you are undoubtedly familiar with a card game or some other game that you've played somewhere in your lifetime where one of the things you had to do was bluff. That is, you had to sort of pretend that your circumstance was better or worse than it was. Bluffing is sort of one thing. Puffing, that is pretending that something just really isn't. You know that you're absolutely just stating a falsehood. That's a much different issue because the ethical rule really does say you're not supposed to lie. At least knowingly. You're not supposed to knowingly lie as an attorney. I've always taken the viewpoint that I'm not going to say anything that I know is false. And so that brings me to this. What do you do? Okay, so those are the three big rules that apply when you're doing legal negotiations. The first two are pretty simple, relatively simple. The second, but the third one's not always as easy. So what are we going to do about, and I'm really gone a long time here, so I'm trying to wrap this up, forgive me. What are we going to do when you know in a negotiation there's things you have to do to avoid saying something? Okay? You want to conceal information. You just do. I mean, that's part of doing a negotiation and getting it done well for the client. Or if you're the client, you're going to want the attorney to be clear about what they will and won't say. So what are some things you can do if you feel like you need to avoid giving something up? Well, somebody asks you a question. Remember my adage, questions unasked or questions unanswered. Anytime you're negotiating with someone, you need to pepper them with questions all the time. Why do you think that? What's your position on this? Do you have any more authority? Who is the person with authority? Who are you dealing with? Who is your client? That may sound crazy, but as a insurance defense attorney for many years, sometimes it wasn't always clear who my client was, quite frankly. And it got to be blurred. Was it the actual defendant who I was defending? Well, that's the position I always took. My client was my defendant, not the insurance company. Yet the insurance company had some authority to do things. And I had to take some of my cues from the insurance company. So it could get a little dicey. All right, so let's talk about this. What do you do to avoid telling somebody something? Here's some ideas. And I'm just going to sort of reel these off, and I'll let you sort of think about them. And I'll tell you what, I'll send you an email with all these in them because there's a bunch, and I don't expect you to write them all down rapidly. Just listen, and then maybe pick one that you want to think about. But here's some possible avoidance techniques. One, don't answer the question that someone has asked you, and then shift to another topic. So in other words, you just start. Politicians are huge fans of this one, right? Now, Mr. Smith, what are you going to do about the huge problem we're having with skyrocketing health insurance premiums? Well, Frank, I really want to take care of people's health. And, I think people should jog more. Okay? And then blah, 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 right? Okay. Answer a different question. I mean, it's kind of a similar technique, right? They ask you a question about, you get asked a question about premiums, and you talk about healthcare delivery systems. It's kind of the same idea. Give an incomplete answer. Say part of the answer. Who is the person in your company who's got the authority to settle this matter? Well, we do have someone in the company. Okay, yay. There you go. Say you'll answer if you get something in return. In other words, that's negotiable as well, right? Well, I'll answer your question if you answer mine, right? I'll scratch your back if you scratch my back, kind of thing. Delay, put it off, find something else to talk about, or simply say I'll get back to you on that. And that's particularly helpful if you get asked a difficult question and you want to think about it and you're on the phone. It's a lot tougher when you're face to face, right? And you kind of go, well, you can always say, can we take a break? I mean, that's probably about the only thing you can do in a face-to-face situation. On the phone, you can always say, hey, I'll get back to you on that. Okay? All right. Okay. Love you. Bye-bye. Click, right? I'm thinking of my wife now, right? Or my son, negotiating with them. Refuse to answer the question and say why you're refusing. No, I'm not going to answer that question because I don't want to, or because my client told me not to, or because it's not relevant, or because that's going to open a can of worms that I don't really think we need to open in this particular negotiation. However you want to put it, whatever phraseology you think you want to use. Say just a little bit about whatever it is they asked. Well, we've got this car. Let's just take a car accident case because they're easy, right? Well, does your client admit that that her light was red at the time? My client remembers the traffic light. Or you can do the Bill Belichick version. Now, again, if you're not a football fan, you won't know who he is. You can go on YouTube, I'm sure, or Google him and do this. My client had a light, and there was a light, and then there was something else. And he just sort of mumbles and talks. It's all nonsense. He does it on purpose. It's all forced, but he just says almost nothing. Calculated ignorance. You can go in, and I will confess I did this on more than one occasion. I would specifically tell my claims handler, don't give me authority beyond X. And they say, well, why? And I say, because if you do, I'll spend it. And I don't want to spend it because I don't think this case is worth that, but I don't want to feel the pressure to get it resolved. And I'm going to feel pressure to get cases resolved. And so I'd rather you give me a little bit of authority, and then I can just say, look, that's all I got, man. And I can honestly say that's all I've got. And so you could do that. I don't have, or maybe your client, you tell your client, don't give me any authority to talk about these two things. I don't want to talk about them. So tell me not to. All right. I guess the last thing I would say about this is pretty much when it comes to legal negotiations, you can't lie. Okay, if you know what you are getting ready to say is just a blatant lie, do not say it, no matter what little words you can use to try to pretend it's something other than just a blatant lie. Puffing, bluffing, whatever words you want to use to say, well, I'm not really lying, I'm bluffing. Well, if you know what's coming out of your mouth is just bald-faced lying, don't do it. Okay, just don't do it. Particularly with legal negotiations, because Rule 4.1 says you can't. You can't knowingly lie. You're just not allowed to. And when I talk to attorney students, JD students all the time, I warn them, this will get you in big, big trouble with the bar. They don't care for this kind of behavior. If people lie and they get caught, they're in big trouble. That's a big no-no among lawyers. Believe it or not, I know people don't think that. They think lawyers are a bunch of ethical scumbags, and it's just not true. That is not true at all. In my experience, lawyers are very cautious and careful about what they try to be, about what they say, so that they don't get into any kind of problems. All right, let me look through my notes here quickly because I think that I am now at the end, and I know I've gone almost 30 minutes, so I'm making up for the last lecture, which was very short. All right, take a stab at the assignment for this unit and jump on the discussion board, and I will talk to you soon.